It gives me great pleasure to introduce our panel of experts on this topic. So firstly, we have Willie Roos, the CEO of Stratafin. Then we have Zerlinda van der Merwe. She is the co-founder and director at TVDM Consultants. Then we have Rudi Heerschop, director at Schuler Heerschop Pienaar Attorneys. And last but not least, Poene Le Roux, a fairly new member of NAMA. He's the owner at MeetingPal. Just to let you all know, the slides and the recording will be available on the website of the session. If I could just ask that you all keep yourselves on mute during the training. Any questions you may post in the chat, and we will make a question and answer document available afterwards. I think that's it. I'm sure it's going to be a very insightful session. Yeah. And thank you to all our participants. I think I can hand over to you.
Yes. Fantastic. Thank you so much. If we can just remind everybody to please place themselves on mute. There's a couple of guys that are answering telephones and all those fun things in the background, multitasking galore. So if we can just ask you to do that. All righty. Firstly, thank you so much to NAMA for the opportunity, and to Willie and Daniela for all the invitations and arrangements, especially Daniela. She always does such a fantastic job of putting these things together and doing our presentations that we're able to share with all of you. So thank you very much for that. So my first slide is dealing with some of the definitions that we're going to be chatting about today. I know a lot of you would obviously have a complete understanding of these, but for those of you that don't, we'll just run through them. Sometimes in the Sectional Title Schemes Management Act, it speaks about a motion. A motion is known as a resolution or a decision. Decisions can be taken by the trustees or the members, and the different member resolutions, as we know, are ordinary resolutions, unanimous resolutions, special resolutions, and of course, there's the written consent of all owners that we know is so difficult to obtain. So when we speak about motion or resolution interchangeably, in this particular presentation, we're talking about the decisions of members. The next acronym we're going to speak about is the STSMA, or the Act. It's the Sectional Title Schemes Management Act 8 of 2011. We're then going to be chatting about PMRs, the Prescribed Management Rules under Annexure 1 of the Sectional Title Schemes Management Act. We'll be chatting about value, or PQ, that's the participation quota. Of course, we know the larger your units in a sectional title scheme, or rather larger your section, the larger the participation quota, and that affects your levy contributions as well as your vote. We'll be dealing, well, Rudi specifically, we'll be dealing with the three types of resolutions, as I said, ordinary, special, and unanimous resolutions. Just a bit of a summary of each. Ordinary resolutions are taken by a majority of members at an annual general meeting or a special general meeting. The vote is calculated only in value or only in participation quota and not in number as well, like special and unanimous resolutions. And some of the examples where we pose or table ordinary resolutions is approval of a budget at an annual general meeting, that is the administrative fund and the reserve fund budget, the maintenance, repair and replacement plan, either at an AGM or a special general meeting, the determination of the number of trustees and the election of trustees, the determination of a financial year end, if that's going to be different to the Act, and then the installation of meters for the supply of water and electricity, for example, except prepaid water meters. So those are just some of the examples of ordinary resolutions. When we talk about special resolutions, we say that the vote has to be taken both in value and number. So value, again, the participation quota of all the sections that you own would count towards the value portion. And if you are one member, you have one vote in number, irrespective of the number of sections you own, provided, of course, that each section is owned in one name. So if I own 5 sections in my personal name, Zerlinda van der Merwe, then I only have one vote in number. But if I own 5 sections in 5 different entities, for example, I would have 5 votes in number. But then, of course, if there are companies and CCs and trusts, I would have to be duly authorized and hold proxies. And then, of course, the whole limitation of proxies come into play, which Rudi will be chatting to us about. The vote requirement here, 75%. 75% of those forming a quorum at a meeting. And Rudi will be looking at a quorum as well. And then, of course, if it's taken via round robin or in writing, it is 75% of all of the owners. Some of the examples of special resolutions: amendment of conduct rules, approving an extension of a section, installing those prepaid water meters, for example. Those are just a few. Unanimous resolutions is the last resolution we're looking at. This resolution, as the name says, is 100% of all of the owners at a meeting forming a quorum of an elevated number of 80%, or 100% of all of the owners if the resolution is going to be taken in writing. This is both in value, participation quota, and number, and as we know, extremely difficult to obtain, if not simply for the 100%, but rather to actually get a quorum at a meeting. Some of the examples of unanimous resolutions in practice is amendment of the management rules and approval of registered exclusive use areas when the body corporate is wanting to delineate and create further exclusive use areas. So those are the definitions we're going to be looking at. If we can go to the next slide. Voting according to the Sectional Title Schemes Management Act, something that I find very often that a lot of body corporates don't do is provide voting cards. Now, interestingly, there's only one place in the legislation that references voting cards, and that is in the prescribed management rules 17.6A to be exact. That is the prescribed agenda of an annual general meeting, or rather a general meeting, and then of course it continues to deal with annual general meeting business, and it is a requirement that voting cards be handed out to the attendees at a meeting. Of course, if it is going to be a physical meeting, physical voting cards can be handed out, which we'll chat about a bit later. If it's going to be electronic or remote attendance meeting, Poene from MeetingPal will be taking you through an example of what those types of voting cards can look like. And of course, if there's a combination, we'll look at both the physical and the electronic. Rudi has got a very interesting example of what will happen if there are no voting cards that are presented at a meeting, which we'll chat about later. I still very often go to meetings where the chairperson says, can we please have a show of hands for a vote? There is no longer a requirement of a show of hands at a meeting. You have to issue voting cards, and the importance of it is that it forms part of the records of the body corporate, which is available to all owners or persons authorized in writing by owners. So you cannot have a show of hands at a meeting. You also cannot say, please put your hand up if you object, or shall we take this as unanimous? You have to use the right terminology. Obviously, unanimous is only for unanimous resolution. And of course, you need the voting cards again. You can't rely on somebody objecting. That would potentially invalidate the vote and the meeting, should somebody challenge it either at court or the Community Schemes Ombuds Service. We spoke about the votes in number. Here are the section references, section 1, 6, 7, and 8, and prescribed management rule 21E, where one member has one vote, irrespective of the number of units that are owned by that member. Of course, if the registered member is the same person or the same entity. So if you own multiple sections in multiple names, even though you are the same person behind it, you still have a vote for each of those units. But if it's all in one name, you only have one vote. Something else, sorry guys, if you can just mute yourselves, please, if there's background noise. Something else that happens very often in meetings is the proposal is made as to a vote or a resolution, and the chairperson asks for a seconder. There is no requirement for seconding of motions or resolutions at annual general meetings or special general meetings, so there's no need to ask for that seconder to be minuted. And of course, if no seconder can be obtained, it doesn't mean that that resolution fails. That's not a requirement. We mentioned earlier, you can take resolutions by round robin or in writing. Rudi's going to be chatting about that process. I did mention the quorum requirements for it for special and unanimous resolutions, and he'll be chatting to you about ordinary resolutions by round robin as well. If a trustee of a trust is the representative of a member. The beneficiaries of that trust are excluded from voting. So that's something to remember when you're doing your attendance, when you're looking at your proxies, to see that the people that are attending the meeting or being represented at a meeting are in fact the correct people, either the registered member or the representative of a juristic entity, such as a trustee of a trust. And then, of course, something very important is that the outcome of every single vote has to be announced at the annual general meeting or the special general meeting. Sometimes I go to quite acrimonious meetings where perhaps the managing agent says, subject to confirmation from our officers tomorrow morning, first thing, we will announce the outcome of the vote. You must always, at least subject to confirmation, announce the vote at the meeting. And of course, with a system such as MeetingPal, where the vote is generated literally in seconds, you're able to announce that outcome at the meeting as it is required to do so. We'll also look at one or two practical examples when we look at the voting cards afterwards. So that's my piece for now. I'll hand over to the next panelist.
Good morning to all, and thank you to Nama for making the necessary arrangements for this webinar. So let's start at the beginning. So for resolutions to be passed and to be adopted, one needs to have a meeting. So let's start at the beginning. So the general rule is that all persons who are entitled to attend the meeting must be given adequate opportunity to exercise that right. So you need to give them notice. So what does the PMR 51 say? It says you must at least give 14 days written notice of the general meeting, specifying the place, the date, and the hour of the meeting. And then such a notice must be given to all the members, to all registered bondholders, to all holders of future development rights, and to the managing agent. But on this point, I just want to advise you that you can, at the start of the meeting, actually pass a member's ordinary resolution to excuse the managing agent. So it is possible to do that at the beginning of the meeting. So what must be contained in such a notice? So the first thing is the agenda. You must put up the agenda, the topics that you're going to discuss, the resolutions that you want to pass or that you want to table must be included in the agenda. A copy or a comprehensive summary of any document that you want to consider or table for approval at the meeting must also form part of this notice. And of course, you need to also include a proxy form, which we will discuss a bit later. The notice must be delivered to the members at their service address. You can have regard to prescribed management rule 4.5 and 15.6.1. Either by hand or by registered post. The members can also decide to receive such notices via email, inform the body corporate and the managing agent, and then the notice can be sent via email. So when we look at what the Act says, it says the notice period, there must be at least 14 days notice for AGM, SGM, where ordinary resolutions are considered. When you're dealing with a special or a unanimous resolution that you want to table for a vote, you need to give 30 days notice. So there are some exceptions, and we'll discuss this when we look at the actual resolutions. And now the one thing that has come, I've received numerous calls in this regard, where the managing agent would say, our friend Eskom has just notified us that there's going to be load shedding. So currently we can do the meetings via Zoom, via Teams. It's going to affect the connectivity. Alternatively, the venue, there's no electricity, there's no generator. Can we move the meeting on for, let's say, a day or two? So nowhere in the Act does it allow, and in the rules, does it allow for a meeting that has been scheduled to be changed. So just take note of that. If you send out that notice, you must attend to that meeting on the day. If because of connectivity issues there's not a quorum, then the meeting must be postponed. But the actual meeting should start on the time and at the place as per your notice. And also very interesting, a failure to give proper notice of a general meeting to a person entitled to receive it does not invalidate a vote taken at the meeting, as long as the body corporate made a reasonable attempt to inform the members and to give the notice. So we've also had numerous matters where a person would say, I did not receive the said notice, I want to invalidate the meeting. So our courts have adopted this benevolent approach towards meetings, and you should prove the actual prejudice that you suffered for a court to consider the validity of the meeting and for the court to turn over the decisions that was made at that meeting. So if we go to the next slide, it's the proxies. This is also a heated debate when it comes to meetings. So a proxy is appointed by a member to attend, to speak, and to vote on behalf of that member at a general meeting of the scheme. A person cannot hold more than 2 proxies. That's the rule. You can't change it. You can't increase it. If you attempt to change your management rule to say that a person can hold 20 proxies, CSOS will not approve it, and you can't. This is one of those unalterable rules in terms of the Sectional Title Schemes Management Act. The managing agent or an employee of the managing agent or the body corporate cannot be a proxy. So you cannot tell the managing agent to vote on your behalf. The aforementioned were excluded to act as proxies. A proxy form must be in the prescribed format. You can have a look at Form C. When one has regard to Form C, it refers to a specific meeting, or you can go so far as to say for all the meetings up until a certain point. The proxy can either be conditional or unconditional. You can actually say to your proxy that they must vote in this manner, so you can make it conditional as well. So when we deal with the proxy forms, it must be delivered at least 48 hours before the start of the meeting to the body corporate. Alternatively, you can hand it to the chairperson before or at the start of the meeting. So that is the 2 requirements to actually act as a proxy. And when it comes to joint owners, they are represented by proxies. So joint owners will have to enter into a proxy, either by one of them or appointing somebody else to act on their behalf. And when we look at the proxy, I just want to let you know that a proxy can be revoked. You can either do it by way of writing, withdrawing the proxy. Alternatively, the member can actually go to the meeting. The proxy can be in attendance, but if the owner comes to that meeting and he acts and he speaks and he votes, by his action, the proxy will automatically be revoked. Next on, I think it's Willie that's going to take us through the conflict of interest when it comes to general meetings.
Thanks, everybody. Thanks to Norma and thanks to the other panelists for giving us this opportunity to do this training session with you guys, and we really appreciate that. Just to come back to a question that I saw popping up on the screen from somebody at Whitfield's regarding a proxy to somebody that has a judgment against them. You are going to, when you give the proxy, I would think that you are now doing a vote or taking a vote on behalf of the person that gives the proxy. So I do not think that the judgment against you will actually have an effect on that proxy, because you are not exercising your own vote, but you are exercising the vote of somebody else. But I think Rudi and Zerlinda can also have a discussion about that a bit later on when we look at some practical examples. Conflict of interest, very interesting subject, and we see it the whole time on the groups where people are asking questions about conflicts of interest and what situation creates a conflict of interest. So a situation where a person is in a position to derive personal benefit from his actions or his decisions, which he will make in his personal or in his official capacity, would be classified as a conflict of interest. So there where you have a decision to make on behalf of the body corporate, and you then can derive a personal benefit from that decision, that is a situation which was a classical situation of where there will be a conflict of interest. Our law in respect of conflict of interest also requires that one does not earn secret commissions or secret profits from agreements. And the reason for that is that once people are hiding stuff, there is a problem with that. And that is why there need to be full disclosure. So somebody that is in a position where they are contracting with the body corporate and they are also in an official capacity acting on behalf of the body corporate must disclose that there is a benefit that they can derive from that decision, and then there should be non-participation, and they should not take part in the decision that is being made. In general, members, however, don't have a duty towards the body corporate. They are not in an official capacity on behalf of the body corporate, and as such, a general member does not really have a conflict of interest situation that can arise. However, we see a lot of perceived conflicts where a member of a body corporate is a contractor, a roof contractor, and the roof needs to be replaced. And that member then gives a quote. And that is then, in lots of times, is that perceived as a conflict of interest, although it is not a real conflict. It is, however, best practice to disclose that member is the contracting party and will be involved in a contract, and also not to then take part in that discussion and decision. But that is not a legal requirement, because he is not in a position where he can actually make a difference to the vote, because the vote is a vote made by the trustees or the employees or the directors of a homeowners association. So that single member cannot really have an influence on the decision, and as such, it can't be a real conflict of interest. So therefore, a member may vote at an AGM or an SGM on contracts where there is a perceived conflict. As I said, it's not what you really want to do, but there's no legal bar against such a vote by a person. We get a lot of questions about people voting for themselves. That is definitely not a conflict situation. You are entitled to be nominated, you are entitled to vote, and you're entitled to vote for yourself as well. So that is definitely not a conflict situation. One can, in your agenda, you can put in respect of an AGM at a special general meeting or a trustees meeting, and normally that forms part of a directors meeting at the company level, where one of the items on the agenda is a declaration that there are no conflicts of interest, and a meeting starts where directors then declare that they don't have any conflict of interest regarding any of the matters on the agenda. So that is something that is done in company law, but it can also be applied with body corporates and homeowners associations as well. Trustees, however, in terms of prescribed management rule 6.3, does have or they are in a position where they can influence a decision, they are in an official capacity, and therefore they have to disclose if there is a conflict of interest. They have to then withdraw from that meeting and not be part of that decision, and not vote in respect of that. Some other interesting management rules, PMR 18.3 I and PMR 18.4, that also requires the chairman to recuse himself as the chairman of that meeting if he wants to partake and wants to give his personal opinion, and then appoint somebody else. and is also prohibited from trying to influence the outcome of a decision from the position of chairman. And that is also in an attempt to stop conflicts of interest. Thanks, Rudi. We'll take over from here.
So the next part that we wanted to discuss is resolution. Now, the default position is an ordinary resolution. So when you read the Act and the prescribed management rules, and they say that a motion needs to be passed, but they're silent on the actual type of resolution, you can assume that the Act and the legislator referred to it as an ordinary resolution. That is why it's the default position. So how do you pass a ordinary resolution? So you need more than 50% of value of the vote of members present at the meeting. So you need to establish a quorum, and then of the people that are at the meeting, you need more than 50% of the vote when you pass the ordinary resolution. When we look at special resolutions, it's adopted in two ways. So the first one is 75% in value and number of votes of members present or represented at a meeting. And the second way is by way of round-robin resolution. You can actually do that. You can pass special resolutions by round-robin, but you need to have at least 75% calculated both in value and number of the members of the scheme in favor of the special resolution, and then same is passed. Now, when one considers the round-robin resolution, when we deal with improvements to common property, that cannot be passed by way of the round-robin resolution. The legislator actually said that you need to attend to the meeting and then pass the resolution there. So the improvements to a common property will be excluded from a round-robin resolution. The notice period, if you want to pass such a special resolution, is 30 days notice period for that meeting. There is, however, exceptions to the rule. The trustees may resolve that a shorter period is necessary because of the urgency of the matter, and then by way of that resolution, call a shorter period meeting and then part from the general 30-day notice. When it comes to prepaid meters, you cannot give shorter notice period. That's also one of the exceptions to that rule. So you can't then deviate from the required notice period. If you cannot pass a special resolution, you can in fact then refer the matter to CSOS. It falls within CSOS's jurisdiction to actually pass that resolution or to get the resolution passed if you struggle obtaining a quorum, for instance, and then you can approach CSOS for assistance there. Now, when we look at unanimous resolutions, it is also adopted. You can adopt it by way of round robin, but then all the members must agree in writing. You cannot have a person not voting in favor of such a unanimous resolution, then it's not passed. The other way is by the members of the body corporate, at which at least 80% calculated both in value and number of the votes, if they are present at the meeting, and then, excuse me, all of the members who cast their vote do so in favor of the resolution. So you need a quorum of 80%, and then everybody at that meeting must then vote in favor of it. There's also a 30 days notice period if you want to pass a unanimous resolution, and there are exceptions to the rule. If it's contained in your rules, which has been approved, then a shorter notice period may be given. Then also likewise with special resolutions, you can also approach CSOS if you can't pass the resolution, for instance, for lack of quorum at the meeting. You may then also seek relief from CSOS. Now, as we mentioned previously, you need to give notice to the members when actually arranging this meeting. You can, however, as a member, waive such a right to notice. So a person who's got a right to receive it may waive such a right by notifying the body corporate in writing. So it must be delivered in writing. the waiver may be revoked at any time in the same way. So that says you can't just phone the trustees and say, well, actually revoking my waiver that I sent you. The Act requires that you do it in the same fashion by actually putting pen to paper and doing it in writing. If 2 or more persons are jointly entitled to exercise a vote, all of them then need to waive such a right. So if you have joint owners, both owners must waive such a right. However, either of them may then revoke the waiver. So the next part is the cooling off, as we refer to it. When you pass a unanimous resolution, there is a cooling off period in brackets. So where unanimous resolutions have an unfairly adverse effect on any member, the resolution is not effective until that member consents in writing within 7 days of date of the resolution. So this is a difficult, I've got an issue with this, because if that member does not in writing consents with it in 7 days, that resolution will fail. It cannot be then considered because he did not act as it being passed. The Sectional Title Schemes Management Act actually requires that you provide that consent. When we look at special resolutions, if a special resolution is adopted where the quorum was less than 50% of the total PQ of the scheme, the body corporate must wait for at least a week before implementing the special resolution. So if in that instance, the week period is for members holding at least 25% in value, may then require the scheme to reconsider the special resolution. In that instance, if you receive that notice, you must call another meeting for the reconsideration of that special resolution. So when we further look at meetings, I often get this call from agents where they say, well, the owner didn't make payment of his levies, he's in arrears with 50,000 rand, can we exclude him from the meeting? Generally, you can't. For special and unanimous resolutions, a member cannot be excluded from voting. However, ordinary resolution, in 2 instances, you may exclude such a person from voting at the meeting, where the member has failed to make payment of his levies, and a court or CSOS has given judgment for the owner to make payment of the arrears. So it's not just being in arrears, you actually need judgment against this owner, and then you can exclude him from ordinary resolutions. And then further, if the member is in breach of any of the conduct rules, and a court and adjudicator has ordered that member to refrain from breaching the rule, then if that member continues, you can also exclude such a member from voting for ordinary resolutions. But again, the rule is not applicable to special and unanimous resolutions. And Willie will discuss abstentions next.
Thanks, Rudi. Right, a very interesting subject, abstentions from voting. So the Act does not really mention abstentions. However, we have a reference in respect of abstentions in Prescribed Management Rule 19.3 that states that abstentions in respect of units belonging to all units belong to a BC are abstentions or voted or counted as abstentions from voting. So firstly, we need to deal with what a quorum is and when that quorum needs to be set up or complied with, and obviously one needs to look at the start of the meeting to determine if there's a quorum. However, that quorum needs to be maintained throughout the meeting and when business of the meeting is conducted. If one has a look at Prescribed Management Rule 19.1, you would see that it says that business must not be transacted at a general meeting unless a quorum is present or represented. So at any time when there is no quorum, then you cannot proceed to make a decision in respect of that decision that is being made. As I said, the current Sectional Title Schemes Management Act does not refer to quorums, abstentions. The previous act made it a vote in favor of that resolution. The current act does not do so. It only speaks about units that belong to the body corporate, and they are saying that they are regarded as abstentions from that vote. So they would not be calculated in determining the quorum, nor would they be utilized in respect of the amount of votes that is required to achieve the resolution. Where the Sectional Title Management Act and the prescribed management rules are silent in respect of abstention, one would follow the common law of meetings, and that you would do in accordance with prescribed management rule 18.3a, which says that the chairperson must maintain order, regulate the orderly expression of views, and guide the members and other participants through the business of the meeting in accordance with the common law of meetings. So because we don't have anything in the Act that actually deals with abstentions, we need to go and have a look then at the common law of meetings that will then give us guidance in that respect. The common law of meetings specifically state that members attending a meeting and members attending a meeting and refusing to take part in the proceedings may be treated as absent or as not constituting part of the meeting for the purpose as to which they decline to interfere. Okay, and that is stated by Arthur Lewin in his book, The Law of and Procedure of Conduct of Meetings in South Africa. So when somebody does not take part in a meeting, wants to abstain, in general, that person needs to, for that specific item on the agenda, need to get out of the meeting, not take part, not discuss, and that can then have an effect on the quorum at that moment. Can a quorum then be achieved? Is the quorum achieved or is the quorum not achieved? I think Poene will also discuss a bit later on that in terms of the software that they are using, that tracks the quorum throughout the process of the meeting to make sure that that quorum is maintained throughout the meeting. Resolutions tabled for approval at an AGM and SGM is calculated in the value of the members present and voting. So there again, in prescribed management rule 21B, we see that we are looking at members that are present and voting to determine if the vote was achieved or not. So again, we have that reference that the person must in actual fact vote for that person to form part of that meeting or part of that quorum. Then in respect of abstentions in homeowners associations, obviously there are different kinds of homeowners associations in terms of the Companies Act, common law and so forth. And one will have to look at the constitutions or MOIs of that, but also at the Companies Act. And the Companies Act requires that a quorum must be maintained throughout the meeting. So it is important that that then is attained throughout the meeting. Once you no longer have a quorum because people are abstaining, then that matter on the agenda cannot proceed and must be dealt with in accordance with an adjournment. Thank you, Zerlinda.
Great. Rudi mentioned during his part that an application can be made to the Community Schemes Ombuds Service if a special or unanimous resolution cannot be obtained, either because the vote can't be obtained or because of quorum issues. Just a reminder that CSOS will be talking with NAMA tomorrow morning at 9 o'clock on their webinar about the Section 6.9 applications under the Sectional Title Schemes Management Act. I think it'll be very worthwhile to attend that. So when it comes to physical voting cards, in other words, a piece of paper or a little piece of cardboard or whatever it might be, although there is only one reference to a voting card in the legislation, there isn't a prescribed voting card or any type of indication as to what must be on the voting card. That being said, The purpose of the voting card is that it forms part of the records, either physically or electronically for a remote meeting, or a combination of both for a combination meeting. And some of the things that would need to be included on this voting card in order for it to be traced back to the owner or to the proxy holder that has exercised the vote is firstly the details of the meeting. So what body corporate is it for? Was it an AGM? Was it a special general meeting? Was it an adjournment of one of these meetings, including when it was held? You could also add whether it was held physically or remotely, and then the name of the registered owner. So in other words, if I own the property in the name of the Van der Merwe Family Trust, I wouldn't write there Zerlinda Van der Merwe, I would say the Van der Merwe Family Trust. The name of the proxy holder, if I was the proxy holder of that Van der Merwe Family Trust, I would then have my name as Zerlinda Van der Merwe as the name of the proxy holder. Very often people don't know what their section numbers are. Sometimes the section numbers and the unit numbers are different. Sometimes the section, unit and door numbers are even different. So either one of those options would be sufficient, provided that you're able to link that detail to the name of the registered owner. So very important that one of those is indeed correct. The voting item also needs to be on the card. So are we voting for the budget? Are we voting for the maintenance, repair and replacement plan? Are we voting for the election of the trustees? The list of the trustees need to be there as well. There's a pop-up question from you, perhaps the participation quota as well, most definitely. The participation quota is a very good idea to have on the voting card. And of course, the Excel spreadsheet or the program that the managing agent or the chairperson is using to calculate the vote will have that participation quota element as well. Whether or not the vote is voted for in favor or against. And then, of course, as Willie mentioned, you don't have the item of abstaining. So that's not a choice. It's either yes or no, not abstain. And then something that I like to add is the signature. And that's simply just to be able to confirm that the person, either the owner or the proxy holder that was holding the voting card, in fact, actually was the one that completed it. Then you start looking at some practical issues that we mentioned earlier. I've been to meetings before where as you register or as you enter the meeting hall or whatever it might be, you get handed the voting card along with perhaps a pack or a copy of the pack, if that's still done. And then you can even sign for it. So in other words, you literally get your pack and you sign the attendance for it to confirm that you in fact have received your voting card or your pack of voting cards. And that's another practical element. Because the outcome of the vote has to be announced during the course of the meeting that I mentioned earlier, it's a good idea that every single vote be on a separate voting card. That if you are at a meeting physically, the managing agent or the chairperson or one of the trustees is able to go around and collect the voting card as you complete it. I've been to meetings before where every single one of those voting cards are perhaps a different color. So that's quite nice to say to people, we're now going to be voting on the budget. We're going to take the green sheet, green for money, or we're going to vote on trustee directives, then it's a pink sheet or whatever it might be. So it almost looks like you get a little raffle book of voting cards. That could work quite nicely. You tear one off when you indicate your vote, you hand it in, the vote is counted, and the outcome of the vote is announced. If you are going to have all your voting items on one sheet, it's going to be very difficult to either keep it all to the end, alternatively to hand that sheet in and out every single time. Something else with the voting cards, just to remember that although there isn't a prescribed voting card, there are examples available. This is an example that was very kindly put together by Stratafin, and this can be obtained by contacting them, alternatively having a look at their website. So this is an example that can be used going forward. I think that's me for now. Yeah.
Thank you, Zerlinda. Over to me then. Thank you for the time, and thank you everybody, and morning from my side. So I'm not going to punt a product specifically. I'm going to mention a couple of things regarding electronic voting, specifically the use of using polls under Zoom and or Teams. The problem using polls makes it difficult in assigning proxies, as well as doing the calculation in value. So they are not a good idea to use. We do find that some managing agents are using forms and or Google Docs, which is will immediately calculate the value votes for you as well. The problem with those is that you can't do what we call a record locking, so you won't be able to restrict one person from not voting on somebody else's cards and or positions as you have access to the full list on a form and or on the docs. So those are just things that one needs to take into consideration. In the past, I've also come across where they were using a survey tool like SurveyMonkey. Again, it's a questionnaire that's sent out. You cannot, in that case, typically make amendments to the wording of the resolution. And as such, they do not comply to the Act in terms of the conformance of making sure that you can identify the person. That is, the chairperson has got the responsibility to be able to identify the person, and through a normal email or a link, you are not in a position to identify the person uniquely. So you've got to look at a system that allows you for registration and with a email that you have on record for the body corporate. And allow that member then to create their own password and then to log themselves into the meeting to cast their votes. Now, I do get the question, what about people sharing their username or their email and password with somebody? I mean, you will get that it's the same principle if you share your banking details. Unfortunately, that does not stand in court in terms of recourse. You cannot have recourse against that. So in terms of the electronic voting cards, again, what we are doing is we have a process where we allow an open and close votes as you step through the agenda, to also assist in obtaining and ensuring that we have a quorum constantly going through the meeting. And structuring the meeting in terms of what items we are on and where we need to vote. I always say, even though when we run virtual meetings, we got to understand that common sense still would prevail. In a normal meeting, we would go through the meeting and we will open up the voting as we step through it, or ask people to cast their votes for complete their voting cards. It's the same principle. When we get to the agenda item, we ask them to complete the vote, and when we can take into consideration their votes. So to the request that was on the paper card as well, it's got to state the specific resolution that you're voting on. As per this example, we are approving the minutes of the 2020 AGM. And then there's the detail just to make sure that we all understand the specific wording as to the vote that we are casting. The system that you must consider should allow for, typically, if somebody says, okay, we want to approve the minutes, but the value should not be paragraph 3 point what should not be 10,000, should have been 100,000. We can make the corrections right away and then put it to the voting with that specific amendments. For the people then to know and cast their votes explicitly to that specific resolution. Furthermore, they need to identify the unit number. And in the example that I've used is this different unit, there's different owners. Therefore, you will be presented with 2 voting cards. And also at the bottom of the voting card, we will then include all the proxies so that you know and can be able to cast the votes differently for the proxies that you hold, given the instructions or directives that you might have on that basis. We do have the option of abstain, and the abstention is a button that we include to track quorum. On the interaction with the system, we can actually then see if we are maintaining quorum. Even though there's no requirement for abstentions, we then get the people to rather stipulate that they're abstaining. But on the right-hand side, you'll see then the results as the people cast their votes. Immediately and dynamically, the system will calculate the vote in value, as well as the percentage vote in whether it's passed or not. And In that case, we then set the specific setting for the system for body corps to ignore, so that those votes will not be taken into consideration. They will just be ignored, but it's for us to track and maintain a quorum and to ensure that we have a quorum throughout. At the bottom, we have a calculator that will determine quorum requirements as votes are casted, so that we can actually maintain and see that we are constantly maintaining a quorum on that basis. On the electronic side, to also take into consideration is once the meeting has or the voting has ended in a normal meeting or in a physical meeting, the chairperson would collect the voting cards, and then that would be written away or stored away for if it gets challenged. The same with an electronic system. The records need to be then frozen. We call it frozen, so that they can't be tampered with in terms of wording, and nobody else can again cast a vote. Even if somebody opens the meeting, they cannot go and open the voting again. Those records are written away, and they can't be tampered with. So those are the considerations that one needs to take into consideration when you run with an electronic voting card. And lastly, it is also good at practice to at the end of every or after every resolution or at the end of the meeting to send a electronic record to email to all owners a record of their votes, so that they have a voting card, a copy of their voting card with them as what was captured in the system as well. And furthermore, one last point is you've got to ensure that there can be no human intervention from either managing agent or the trustees or anybody between yourself casting your vote and then somebody then actually then capturing the vote in the system. That allows for transparency and good governance, so that nobody can interfere with your results. Thank you. That's all from my side.
Just as an FYI, Poene kindly attended to a demonstration for our database yesterday. That recording will be made available on our website. Nicole has confirmed that it is available on our YouTube channel in the meantime. So just keep your eye on our website today or tomorrow. Otherwise, pop me a mail and I'll send you the link to it. But that was about an hour and 15 minutes full-on in-depth presentation on MeetingPal, how it works, as well as dealing with quite a few questions from the audience as well. Definitely worth a watch. Looking at voting via combination, both physical and electronically. Poene has got an interesting story about this, which she'll mention in the next slide or two. But in terms of prescribed management rule 17, 10 and 11, remote attendance or electronic attendance at a meeting is possible, both at a physical meeting, alternatively without there being a physical meeting. The acts
Zerlinda?
On your side as well.
Yeah. Hi everyone, sorry, it seems like Zerlinda's just been kicked off there, or something's happening with her side. Let's continue though. Let's Willie just continue talking about voting electronically and in physical. Sorry about that. I'm sure Zerlinda will be back in a couple of minutes. Otherwise, Poene, if you want to continue with this section.
I'll do that. So just in terms of physical and electronic, yes, the Act does allow for so-called mixed meetings where we can meet in person and with the enhancement of electronic, of telephone or any other method. What needs to be taken into consideration there is that it does require a bit of an infrastructure. If you run a mixed meeting where people are in a specific venue, apart from the COVID requirements and regulations that you need to comply with, one needs to consider that if you typically run a Zoom session with remote participants, you would have to have a facility in the room with proper sound and omnidirectional speakers and microphones for you to communicate effectively with your audience or the people that's remote. And then also based on the position of identifying them. Again, you need to ensure that the electronic tool that you are then using allows for a mixed meeting in terms of people in the meeting room to be casting their votes, all the votes to be captured done afterwards when they were done on a voting card. My recommendation is to use a tool that's got an application that will allow you to capture, even if you are in presence in the room, to capture your vote from your phone, so that we do not have the position where people remotely cannot see cast their votes. In that sense, we use the same method of voting and ensure that people in the room and remote people are using the same system, so that the results are updated immediately and can be announced by the chairperson directly after the voting has been concluded or at the end of the meeting, depending on the structure of the meeting. That's from my side. Zerlinda, are you back?
Yes, Poene, thank you so much. That was completely a test, just to show you that you need to be accessible and be able to communicate. No, unfortunately, my Wi-Fi abandoned me at that moment, so I apologize for that. Poene, thank you very much. That is all that I would have liked to say for that.
So we've got a couple of real life examples here, and Willie's going to take us through the first two, and then we'll continue with others.
So the first one we actually did discuss previously under conflict of interest, that we get a lot of questions about. Is a person entitled to vote for himself as a trustee? That would not constitute a conflict of interest, and a person would definitely be entitled to vote and make sure or vote for himself to get onto a board of trustees. The second one that I've been involved in was a body corporate where the chairman's company was a company that does roof repairs, and the 3 quotations were given at the AGM as part of the decisions that needed to be discussed and made or given to the owners, so that they would be aware of these decisions that will be made by the trustees once they are appointed. And at no stage did they disclose that the chairman was actually the owner of the company that did the 1 quotation. During the discussion, it came out
Willie, you're on mute. Willie, you're on mute.
Hello, am I back? Am I back?
Yes,
sorry.
Yes, you're back now.
Did you guys hear Zerlinda? Sorry, the voting.
Up until quotation. The quotation was the last word.
All right. Okay. So the trustees or the chairman did not disclose that his quotation formed part of the 3 quotations or his company's quotation. And then during the meeting, it came out that his company was actually the 1 company. So that would constitute a conflict of interest if he was appointed again as, well, like he was in this instance as a trustee, and he would then earn a income out of that contract where he's dealing in his official business as a trustee and make decisions on behalf of the body corporate. So that would be a real conflict of interest situation where there would be a problem where he should not be allowed to vote and should vacate the room and not take part in the vote and discussion in that respect once that decision is being made.
Thanks, Zerlinda. And Poene, you were discussing earlier the combination or mixed meeting real life example.
So
I'll let Poene go through that.
Thank you. Yes. So what we do find is sometimes, or in a lot of cases, the meeting, even if it's mixed meetings and or virtual meetings, is where they are run as webinars, where the remote participants are muted and cannot participate in the discussion, where they need to raise their questions in the Q&A section. And that is in contravention with them being able to participate and voice their voices on the meeting and on the matters to be discussed. So one can argue that if it's a single remote meeting and everybody is muted, personally, I don't appreciate that I would not be able to voice my opinion during a meeting, perhaps just because I'm a vocal person. But we've seen that happen in real life examples as well. Rudi, I think the next one is for you.
Yes, so we're currently busy with a very interesting matter where the managing agent was on the chopping block and was formed part of the agenda of the meeting. At that stage, the scheme decided to, or table the resolution to be passed for the termination of the managing agency's agreement. What transpired at that meeting is the managing agent was present. However, when they did not convince the members to not vote in such a fashion, they then recused themselves from such a meeting, but they left with the actual voting cards. The meeting proceeded. The necessary resolution was passed, and this is the current point that we refer to court, because in hindsight, the managing agent is now claiming that the failure to vote via voting cards invalidates the actual meeting. We are of the view, even though that the legislation requires voting card, that in that instance, you can actually convince a court to agree that the voting cards were not necessary for that meeting when considering the facts, and that the resolution will pass. As I mentioned, we're currently busy with this matter. It has been referred to the High Court, and hopefully we'll be obtaining judgment, which I will share with all of you when we get that judgment. But I think in certain circumstances, especially when you act maliciously in that circumstance, the court won't invalidate a meeting by if you didn't have voting cards. However, that your minutes of the meeting was actually to such a point that you can establish who voted, how they voted, and what was the actual the votes in favour. So yeah, that was a very interesting matter that we're currently busy with. So yeah, thank you guys. I think Zerlinda will be chatting about examples of HIs next.
So we were mentioning when we were doing our dry run earlier that it's so difficult to give concrete advice or guidance on homeowners association, simply because each one is different. It depends on its constitution, if it's a common law association or its memorandum of incorporation or the old articles of association, and of course the Companies Act if it's a non-profit company. Willie mentioned earlier on about HAs when it comes to abstentions, and when it comes to things like quorum and abstentions, one has to look at what the Companies Act says, and the Companies Act's provision is very similar to what it is in a body corporate under the Sectional Title Schemes Management Act. There must be a quorum, and that abstentions obviously affect that quorum, which is in line with the common law of meetings. And of course, for common law homeowners associations, where the constitution is silent, one references the common law as well. So it's very important to look at the memorandum of incorporation or the constitution in order to see what can and can't be done when it comes to voting, notice, quorum, etc., etc. There was during the heart of lockdown, although one can say we're still in the heart of lockdown, but in any event, there was quite a flurry of questions coming forward from members in homeowners associations as to whether or not they could hold meetings remotely, even if their constitutions didn't allow for remote attendance. And in sectional title, we know according to the Sectional Title Schemes Management Act that remote attendance is allowed. But if your constitution is silent on that fact in a homeowners association, simply because of lockdown, it didn't mean that you could necessarily meet via remote attendance. You would have to go through the process of amending your governance documentation and of course having a look at what those requirements are to put that in. So we're finding more and more, irrespective of the size of the homeowners association, that when we are asked to amend its governance documentation, things like quorum, limitation of proxies, abstentions, voting via round robin or remote attendance, calling meetings remotely, those are the types of things that homeowners associations are wanting to now incorporate into their governance documentation. That hasn't been the case before. So that's just something to keep in mind for a homeowners association.
Okay, I think that
Willie,
brings us to
you muted. Sorry, I see Willie's trying to say something here, but he's muted himself. Okay, he said it's okay.
I think that brings us to the end of our training. If there's nothing else from the presenters, I just want to say thank you to everyone who attended, and also a big thank you to all the presenters for sharing your knowledge with us, and also for all the effort you put into getting this training session together. We really do appreciate it. And then, as Zerlinda said, please remember to register and attend our webinar tomorrow with the CSOS. It's going to be on Section 6.9 resolutions, and it starts at 9 o'clock. All right. Thanks, everybody.
Thank you so much, everyone.
Thank you so much, everyone.
Thank you.
Thanks. Bye-bye.
Bye.
Bye.
Bye.